Thank you, DeRay. I am so looking forward to this discussion about some of the questions that have been on my mind so much about the Supreme Court over the last several months. There is just a fabulous array of people here to delve into these questions. And first, I just want to start by thanking Alliance for Justice for putting this event together. And to say a big thank you to Nan Aaron, who has been a force of nature in Washington, D.C. for more than 40 years. I have known Nan for what feels like my whole life. To say that she will be missed is just an understatement. And I just want to honor all of the effort and energy she has expended over this long tenure. So to introduce our panel, our first panelist is Elie Mystal, who is the justice correspondent for The Nation. He covers the courts, the criminal legal system, and politics. Elie is a graduate of Harvard College and Harvard Law School, and you can see him all the time, if you're lucky, on MSNBC. Our second panelist is Chris Hayes, who is the host of All In with Chris Hayes on MSNBC. Chris also serves as the editor-at-large of The Nation, where he's been contributing since 2007. He's a former fellow at Harvard University's Edmund J. Safra Foundation Center for Ethics. And our third wonderful panelist is Michele Goodwin. Michele is the Chancellor's Professor of Law at the University of California, Irvine, and the host of a popular podcast on the issues with Michele Goodwin at Ms. Magazine. She's published 6 books, more than any of the rest of us, I think, and more than 100 articles, essays, book chapters, and commentaries. She's been published or featured in places like the Harvard Law Review, the New York Times, Ms. Magazine, and Politico. So welcome to all of you. Michele, I'm hoping you can kick things off for us. And I want to start with a topic that I think is weighing heavily on many people's minds as they think about the Supreme Court. And that is the future of Roe versus Wade and people's constitutional right to access to abortion. DeRay mentioned that the future of a Texas law that imposes a near ban on abortion after 6 weeks is looming before the court. That is also true about a near ban at 15 weeks from Mississippi. And Michele, the sort of big overarching question here is about whether the Supreme Court is about to effectively or actually overturn Roe, what a more kind of incremental decision could look like, and just where you think this is going to go. We have a new dominant conservative majority on the court, but on this particular question, as a group of 6, they are untested. So what do you think is going to happen and why?
Well, tested and untested. We got a bit of a preview in the Texas case when the Supreme Court had the opportunity to intervene, and that is to say to allow the district court to finish its review or just simply allow for the law to not go into effect through its shadow docket opinion, which basically was 1 page unsigned, so we still don't know which justice actually wrote that opinion. The Supreme Court effectively allowed the law to go in place. And since that time, there's been a bit of civil procedure gymnastics that's taken place in Texas, which was the purposeful design of the law itself. But if we actually take a page from that particular case, it's important to note that even Chief Justice John Roberts, who is not necessarily a friend or fan of reproductive health, rights, and justice, dissented in this case. Now, what's clear is that his dissent, at least in terms of counting balls and strikes, does not matter with a group of 5 that can carry an ideological bent against abortion rights to a vote that suppresses or oppresses reproductive health and rights. And it's important to note that when we look at this cast of 5, it includes people who both publicly, outside of their judiciary roles, and also on the court have articulated strong stances against reproductive health and rights and justice. So that includes Alito, that includes Thomas, Kavanaugh, we see that from the DC District Court. We saw that from Gorsuch when he was previously on the 10th Circuit. And then the real card will be Amy Coney Barrett, but she told us from the Rose Garden at the White House that she sees herself in the vein of Justice Scalia. Scalia was not a fan of reproductive rights and justice. So, we still don't know, right? We're not bringing a Ouija board to this. But at the same time, there are indications from past jurisprudence with these very justices that should cause us all alarm.
Elie, I would love for you to pick it up from there. Are you alarmed?
Right. I'm totally alarmed, but not exactly about SB8. Look, SB8 is terrible with the bounty hunting but among friends, I think we can all admit that SB8 is a little bit weird. It's a little bit kind of out of left field. It's got some weird standing issues. I still think, call me naive, I still think that there's a good chance that eventually, when we get to a ruling on the merits, that this Supreme Court will strike it down. The problem is Dobbs. The problem is Dobbs v. Jackson Women's Health. The problem is the Mississippi law that bans abortion at 15 weeks, that the court was already slated to pick up before Texas acted a fool, that is going to be argued on December 1st. And that is the case that I believe the conservatives have designed to strike down Roe. Of course, they won't actually say we're striking down Roe, because if they said that, people might notice, hey, who are these unelected justices taking away? No, they're not going to say they're going to strike down Roe. They're going to move the line from fetal viability, which is where it is in Roe and Planned Parenthood v. Casey. They're going to move that back to 15 weeks, call it not an undue burden, because 15 weeks, women can still figure out how to get an abortion. And so it's not an undue burden on their right to choose. And then the conservatives can still say, oh man, yeah, we got this victory, but Roe's still a thing, so give me money to stop the baby Holocaust. And Democrats, centrist Democrats, can still say, hey, Roe's still a thing. What do we got to do? Why are you asking me? We're fine. Like, that's my fear of what the Supreme Court's going to do.
Let me just quickly pick up on that, Emily, to what Elie is saying. This has been a death by 1,000 strikes. But let's also be clear about the evolution of conservatives on this question within the context of the court, because there are some that would say, well, look, this has always been the Republican point of view. And that would be absolutely incorrect. In 1973, in Roe v. Wade, that's a 7-2 decision. 5 of those 7 justices are Republican appointed. We've got Justice Blackmun, who writes the opinion in Roe v. Wade, and he's Nixon appointed. Nobody's challenging Nixon's Republican bona fides. The same is true 20 years later in Planned Parenthood v. Casey, a case that significantly O'Connor and Kennedy play a pivotal role, both Republican appointed. So what we see today in terms of the Supreme Court and the ideology coming about is what would have been described 50 years ago as absolutely fringe.
Yeah, and I think it's also, what's striking about that point is that it's precisely those traumas that produced the modern assembly line to make sure that the next justices that are appointed are going to be right on this. That's what we've watched develop, obviously, after O'Connor and Kennedy and Souter. And, we have come to the point that was 20 years in the making, and part of what's so maddening, of course, the discourse around all this with, both the court declining to enjoin the Texas law despite its sort of procedural preposterousness, and also Amy Coney Barrett coming from the court be like, who, me? Abortion? Never really thought of it. I don't know. Like, what are you talking about? Like, all of this nonsense that we all know what's going on. We all know the subtext. And to Elie's point, I do think, like, I'm not a lawyer and I'm not a legal expert here, but I do think the politics matter here. And I actually thought the Roberts dissent on the procedural motion on the SB8 was interesting. I think it also was interesting to conceive of the politics of the decision should it come, to Elie's point about whether they explicitly strike down Roe, and also where Roberts ends up on that. Because I think that he is, almost more than anyone on the court, certainly more than anyone on the court, extremely attuned to the political ramifications, to the legitimacy of the court, yada, yada, yada.
He's the Chief Justice.
Yes. Yeah. You're right. It's his role, but I also think he's really a creature of the sort of Republican Party in a lot of ways. I guess Kavanaugh is too, but I think it'll be interesting to see how they do that, because I do think, look, the politics of this issue are complicated, and the polling on this issue is complicated. One of the things that is a robust and constant finding is that people like Roe. They like that is a pretty consistent finding across polls over time, over wording. Like that result happens, and I don't think Sam Alito cares one way or the other about that. In some ways, it's not his job to care, but I do think Roberts cares, and I think that we'll see how that plays in. I also think the last thing I'll say is the fact that they're so tetchy right now on the court about criticism between Alito, like, giving his speech against Adam Serwer's piece in The Atlantic precisely on the court's decision not to enjoin SB 8, Amy Coney Barrett appearing at the McConnell Center in Louisville next to Mitch McConnell to claim that she is not a hack and has no political affiliation. They are aware of what is the incoming. They are aware of the perception. They're aware of the polling that has shown their legitimacy and approval at an all-time low. And I think that factors in too. Now, it's not dispositive anyway, but it's present.
Oh, no, absolutely. And let me just close out with this, right? So we can see that Roberts has cared about the legitimacy of the court even before the recent dissent. In June Medical v. Rousseau, we get to see a hint of that, of Roberts trying to save the court, or at least save the reputation of the court before SB 8 in another abortion case that just 2 years ago, where the state of Louisiana tries to stand down the Supreme Court, basically saying, well, we can pass the same kind of law that you've just struck down 2 years ago. And I think a lot has to do with the Trump administration calling out Obama justices, et cetera, and Roberts having to stand up, right, and saying there's no such thing as Obama judges, justices, Bush justices, et cetera. So this has long been on his mind. It's a great question. And I think Elie and both you, Chris, really great commentary on it.
Okay, so that is an excellent segue to our next question. I want to dig into what is going on here with justices like Justice Barrett and also Justice Breyer, and I suppose in his own way, Justice Alito really trying to defend the court against criticism. So the context here is the court's declining public approval rating. I think a year and a half ago, it was at 58%, which is like around the sort of 60% high water mark that we've seen for the last 20 or 25 years. It's since dropped to 40%, which I think is an all-time low since Gallup has been keeping track. What, Elie, do you think is going on here with the justices' pushback? Are they making exactly the kinds of remarks about how the court is nonpartisan that they kind of always make? Does it feel less credible than usual to you? Is there this sort of intrusion of realism that they just kind of can't resist talking about? What do you make of what's happening here?
Well, I want to roll the tape all the way back. Let's go Federalist 78. Alexander Hamilton says that the Supreme Court is the least dangerous branch of government. Now, Hamilton was wrong. Hamilton was, Aaron Burr ain't going to shoot me level wrong, right, about this idea. But why did he say that? Well, because the court has no money and the court has no army. And Hamilton's thought, again, completely wrong, but Hamilton's thought was that the court would never get too far out ahead of the political institutions because they would pull the court back given that the political institutions, Congress and the president, actually have powers that the court doesn't, right? Fast forward all the way to our present day, and what we see is that the political institutions have put upon the court the charge to do these massively unpopular things that they cannot get done through the normal political process. You could not pass a bill through Congress banning Roe v. Wade. You couldn't get it done. You couldn't pass a bill through Congress eliminating gun laws, eliminating gun permitting, which is what also the court is going to do. You couldn't pass a law through Congress eliminating the Voting Rights Act. All of these things are critical things to the functioning of our democracy and the distribution of our rights and responsibilities, and Congress has given that over to the Supreme Court to handle it. Well, once you do that, of course, people are going to start kind of looking at the Supreme Court a little bit differently and criticizing the Supreme Court. The Supreme Court is the least transparent, but also the least understood branch of government. It's the least covered branch of government. One of the reasons that I like Nan, since that's what we're talking about, is that she has spent her entire career trying to bring this, clandestine branch of government to light, not necessarily for, left-right politics, but just so people understand, because if people could just understand what the court does, they wouldn't like it so much. They wouldn't like unelected, unaccountable, lifetime appointed judges deciding for them what rights they have and which acts of Congress are legal or not. They don't like it. And what we're seeing today is the proof of that pudding. When the Supreme Court has it put upon them to decide these issues outside of our political process, the people disagree.
So one thing that's really interesting about that critique is that, historically there have been moments, throughout our history, before the Civil War, after the Civil War, particularly involving race.
That's what I'm thinking, Emily.
What? Sorry?
I said that's what I'm thinking.
Right? We've seen the court take the country backwards at other moments. And yet, I think largely because of the role that the Warren Court played in the 1960s in a way that a lot of liberals favor. Liberals often look to the Supreme Court to defend the rights of minorities. They see its judicial supremacism, its expressions of power, or they have seen as a kind of positive force in American life. You were painting a very different and darker picture, Elie, and I wonder, Michele and Chris, in that historical context, what you think about the court shifting role.
Well, it also says a lot about the arc and evolution of the Constitution actually doing the work that it was intended to do in the lives of people of color, in the lives of women. So you're absolutely right, Emily, to say that, well, look, we could look at cases like Dred Scott, where Chief Justice Roger Taney says that Black people were never intended to have any status above property in what we have as the United States. And for him, that was the vision. Or Prigg, when the Supreme Court upholds fugitive slave laws and striking down states' laws that would say, hey, if you're Black and you make it to our state, you're going to be free. The Supreme Court playing an active role in that. Or we could look at the history of jurisprudence, which has been absolutely barbaric and arcane with regard to women, right? There's the vestiges of it all happens to be there. But what we've also seen over time, not always through federal legislation or through state law, sometimes anything other than that, social movements and people coming into their own, people of color being able to actually make their way through colleges and schools, women doing that so too, able to be empowered and such then to be able to speak clearly about the gaps in the court, right? It says a lot about whose voices matter. And I think that's part of the point of your second question, Emily, because over time, it turns out that the court hasn't been great. You look at 1927 and Buck v. Bell, where the United States Supreme Court upholds a eugenics law out of Virginia that becomes the model for the Nazis' eugenics law. Not so great. Korematsu, not so great. But I think now there is a different standard that folks want to hold the court to. And you're right. It doesn't look in any way the way in which the Warren Court did.
I mean, I guess there's sort of a charitable way to interpret all the caterwauling and an uncharitable way to interpret it. And I tend towards the latter, but just to give the argument for the former, like, look, I think you could make the case that if you survey the institutional landscape of American democracy at this moment in the 21st century, like it's in pretty rough shape. You have, you just had the first violent interruption of the transfer of power happen since arguably the cannons firing in Fort Sumter in the wake of Lincoln's inauguration. Like, you've got this sort of brewing authoritarian cult that has essentially come to take over one of the two major parties that clearly is antagonistic towards the rule of law and democracy. And in that landscape, it's important to have some kind of like repository of widespread authority, legitimacy, and reputational capital that can issue a decree like the election result was X. And that the court is worried about, and I think across the ideological spectrum, that people in the court are worried about the ability to project that authority when essentially the time comes for it, when it's like the break glass moment of the constitutional crisis. So that I think is the charitable view of it. I mean, the uncharitable view is like, nothing drives me more insane than what I find to be the sort of tendentious bad faith of particularly the right, I think, on this with the balls and strikes stuff. This, oh shucks, like us, like me, the guy who just had dinner with Leonard Leo, like what about me? I don't have any politics. Like I do think that has been harder to maintain in this era for a bunch of reasons. One, the structural polarization that's playing on the country. Two, like when you get up next to Donald Trump with Ruth Bader Ginsburg not even in the ground, everyone, people are going to understand what's going on. So I think like from the Merrick Garland situation through the fact that 3 justices are confirmed by this guy who loses the popular vote, including the last one right up to the deadline, like that is going to have an effect, at least on one big chunk of how the country, which was the chunk, I think, to your point, Emily, and to yours, Michelle, like more disposed to have sort of positive views. Like, I don't think that those people, and I'm speaking here broadly, the center, left, and liberals, are as disposed to have those positive views given what we've just gone through.
I mean, I think that the reason why we know that the charitable view is not the view that the current justices have is that if that's what they thought, the people they would be angry at are not Adam Serwer, they'd be angry at Mitch McConnell. Because Mitch McConnell was the one who broke it. Mitch McConnell was the one who refused to give Merrick Garland a hearing. Mitch McConnell was the one who installed Amy Coney Barrett before Ruth Bader Ginsburg was in the ground. Quite frankly, if those 2 justices, if Gorsuch and Barrett were concerned about legitimacy, they would have told him no. They would have said, no, I do not want my entire career sullied by your partisan hackery. Get away from me. Instead, we've got Amy Coney Barrett sitting, at the McConnell Center talking about how she's not a partisan hack in the most partisan hackish way. But I also want to say, like, when we think about overall the legitimacy of the Supreme Court, we cannot let it pass that what we're seeing right now, to get back to the first question that was asked to Michelle, what we're seeing right now is 2 of the 5 votes to take away women's reproductive rights are being supplied by men who have been credibly accused of sexual misconduct. When you think about the legitimacy of the institution, you cannot separate out that from the allegations about Clarence Thomas, which I am thinking of because he just passed his 30-year anniversary of confirmation, and the confirmation hearing of Merrick Garland, where this man was credibly accused of attempted rape, credibly accused of
Brett Kavanaugh. Sorry, Ellie. Confirmation hearing of Brett Kavanaugh.
Of Kavanaugh, credibly accused of assault, credibly accused of perjury, credibly accused of having disappearing debts, and his alibi was a calendar whose chain of custody was him and his dad. Like that, like you can't get around that kind of that issue when you think about why doesn't the public respect the Supreme Court as much as it used to.
And could I just add on to that, Emily, that as we think about this, it's really important that we understand that we're not talking about just the Supreme Court. When you think about the power of the federal courts or state courts, I mean, Donald Trump, while he was in office, was able to nominate and then get through, with the help of Mitch McConnell, more federal judges than any other president save George Washington. And in the space of all of that, not one Black person on the federal courts of appeal. Right? I mean, it is also very draconian to just look just the substance of what happened and who now serves on the court. I mean, the very fact that the ABA process of vetting was pretty much disregarded, and there are reports of some of these judges as being unqualified to sit pretty much ignored, and then something else that relates fundamentally to what you've asked us to think about. 2 cases that over the course of the last 40 or 50 years have been important questions to ask the people who sit before the Senate. Brown v. Board of Education and the legitimacy of that case, and Roe v. Wade. And in this particular period with the Trump nominated judges, we saw people saying, I don't know, I can't actually say that Brown was rightly decided or that I would support that opinion. That was stunning.
I want to move us to this sort of big looming question about the future of the court. So the Alliance for Justice supports expanding the number of justices as a way of addressing the political realities that you're all describing. That is not an especially popular idea right now, in part because it's associated with President Franklin Roosevelt's attempt at what is come down to be called court packing, as a response to the Supreme Court at the time refusing to uphold parts of the New Deal. I always feel at this moment obligated to mention something from a really good book about the Supreme Court and public opinion by Barry Friedman, which was that at the time, it wasn't at all clear that court packing was actually unpopular when FDR first announced it, but it has come down to us as corrupt, effectively, as one or two branches of government trying to kind of discredit and pound on the third one. So what do you think, Chris, about the future of the court? You know, if the justices really issue major decisions that make it appear that the law is just lurching to the right in a dramatic fashion, is that going to change the kinds of remedies that the country might be willing to accept?
Well, the question is, what do you mean by the country, right? Because I think that a certain portion of Democrats are probably there, but definitely not the institutional Democratic Party. It was very clear to me that Biden never had any interest in it. You don't even have the votes right now to get rid of the filibuster, which is far, far, far less a dramatic kind of institutional reform than adding seats to the Supreme Court would be. Look, I think that the gravity of American structural polarization pulls everything towards it in a way that will produce increasing pressure for these kinds of actions on the court. Right now, I think there is a thinking that I think is genuinely held, though to my mind, probably wrongheaded, and I know Elie thinks extremely wrongheaded, that, that essentially among the kind of Democratic Party elite and establishment, that upholding norms in some ways is part of the bulwark against the encroachments on our democratic health. And that if you get involved in essentially a race to the bottom, then you are unwinding, you're taking part in the kind of deconstruction of precisely the kind of structures that you need as bulwarks against what is, I think, acknowledged, I think, by most of the folks in that cohort, including the President of the United States, as like a genuine threat to American democracy as we've come to understand it. That said, I think that the political pressure from the bottom up is going to, it really depends on what the court does. And in some ways, the only silver lining here, I do think, to bring it back to what I was saying in the beginning, is in the same way that the understanding of the resolution that happens from so-called court packing, court expansion, court right-sizing in the New Deal is that there is a kind of, political settlement between the branches that shakes out the switch in time that saves 9, the idea that like they kind of turn a corner on the New Deal jurisprudence, and that maybe the political pressure had something to do with that's contested in the literature, but the notion that there are political forces acting on the court. And I do think that part of the reason they are so touchy about criticism right now is that this idea looms out there. I do think that like the best case scenario, silver lining way to interpret this is that the threatened cudgel of intervention by the other political branches perhaps acts itself as some kind of check in restraining the branches from restraining the court and the courts from doing the worst things that they might be inclined to do.
If you are a Republican running for Senate and you are soft on the courts, you will lose. If you're a Republican running for president and you are soft on the courts, you will lose. You will not win your primary. If you're a Democrat running for president and you're soft on the courts, it does not matter yet. Biden was far and away the most hostile to court expansion, court reform, whatever you want to call it, and it didn't cost him a vote. It didn't cost him a vote in the primary, and he knew it, and that's why he's acting the way he's acting right now. It doesn't cost Dianne Feinstein a vote when she hugs Lindsey Graham. It doesn't cost Chris Coon a vote. It doesn't cost Joe Manchin a vote. It doesn't cost Kristen Sinema a vote to be soft on the courts and to be unwilling to do what is necessary to protect the democracy from the Republicans who have flooded the courts with their chosen people. Now, the only way that changes is when it starts costing these people, these politicians, these elected Democrats running for Senate. The only way it changes is when it starts costing them in the primary. And I think that we are some distance away from that because the public, the Republicans and the media in general have done a really good job of framing the Overton window here and putting court expansion off to the side. So even the general public, when I talk about this a lot, they will say to me like, whoa, well, Elie, if you expand the courts, then the Republicans are just going to expand it right back. And then, well, how's that worse? They have 6-3 majority now. How is a 16-13 majority sometime in the future worse? Tell me how it's worse. They can't, but they've been trained to say like, but we have to be careful. So the Overton window is such that you are still pretty far away from getting enough people to even understand the courts, understand how it can be reformed, understand how it can be changed, and then to put pressure on their Democratic elected officials. The Republicans don't have this problem because they have spent a generation, and I've talked about this a lot, Republicans have spent a generation telling their voters, who are no smarter than the Democratic voters, it's the same kind of level of education, I think, about the courts in general, but they've spent a generation telling their voters that anything they don't like, they have to get the Supreme Court. You want your guns, you got to get the Supreme Court. You want to stop abortion, you got to get the Supreme Court. You don't like two men kissing each other at a restaurant, you got to get the Supreme Court. Republicans understand that, Democrats don't.
So, let's just be clear, and I'll be really quick here, that it's not been since Jimmy Carter where there has been an active lens from a Democratic president about the shaping of the courts. And Jimmy Carter was an expansionist president. And in fact, it's worth looking at his record, which most people don't. He put more women in the federal bench than any other president prior, all combined. And this included Black women as well. There's not been a president since that has gone at this with the level of kind of an analytical eye from at least a Democratic point of view than Carter did. And I mean every Democratic president since Carter.
Can I say one more thing? I just want to say that my monocausal theory of the asymmetry between the two coalitions that Elie is 100% correct about is Roe. It's the valence of Roe. I mean, I really think like that's the story, is that they have mobilized over 30 years around Roe, and they have it's a perfect marriage between the grassroots evangelical Christians and the corporate interests that want to get rid of basically the New Deal and go back to Lochner era. But the reason they've been able to get their grassroots is that it's about Roe, and liberals have been way more sort of copacetic because they were on the right side of Roe. And I think that's why what's about to happen is such an enormous inflection point, precisely because this defining issue, I think, is not just defined reproductive rights in this country. I think it has been the overwhelming thing defining grassroots small d Democratic politics around the court for essentially, decades.
Right. I've done so many interviews with voters over the years in which they seem overwhelmed by the choices in front of them, and then they turn to abortion as something they have a clear, firm moral position on as a way to distinguish between candidates. I just want to give each of you a chance to make one final point, a lightning round, in what has been an excellent discussion. Elie, why don't you kick us off?
Oh, I was... my final lightning round point. Whatever you do in terms of court expansion, court reform, what have you, the thing where Democrats need to focus, where Alliance for Justice has already been focusing, is that we are due for a lower court expansion. The Judicial Conference has recommended at least 70 more judges at the district and circuit court level. We are overrun at that level in terms of just raw caseloads. And so even though it looks like actual Supreme Court expansion might be out of reach, we have to bear down and get meaningful lower court expansion going, because I promise you, if Mitch McConnell takes back the Senate and a Republican president wins in 2024, that is the first thing that they'll do. Not Supreme Court expansion. They will expand the lower courts because A, it's actually needed, and B, they can flood them with all of their justices. So if you don't get lower court expansion done now, today, now, then the Republicans are going to do it potentially in 2024.
Chris, you're nodding so vociferously that I'm calling on you next.
Well, I just, the last thing I would say is here's one more asymmetry that I think is really bedevils the Democratic Party and the center-left coalition. It was really remarkable how little Mitch McConnell and the Republican Party wanted to do with power on domestic policy. They tried to repeal Obamacare. That didn't work. a big corporate tax cut and top income level tax cut. That's what they do in every, that's always what they do. And then there was nothing else. And then effectively all they did was judges, because that's all they care about. That the ideology has been whittled so thin over there. The notion of some programmatic vision of what American domestic policy should look like is so skeletal that Mitch McConnell just clocks in, confirms judges, clocks out, sends them on recess, and did that for a year. Now, that makes it easier on their side, because the Democrats really do have a much larger, more ambitious substantive agenda in terms of like structuring American political economy. And you're seeing that play out now. I think this administration has been pretty proactive on judges, but again, it's competing for airtime and attention with like 5 other huge pieces of legislation they're trying to get passed. You don't have that on the other side, and that really does end up benefiting them in terms of their ability to focus on the courts.
Michele, take us out.
So what we're talking about are real life matters that actually affect people's lives. These are not just simply abstract commentaries that you've heard today. When we think about abortion, for example, with the Mississippi case that Elie brought us to, we're talking about a place in which there's only one abortion clinic in the state. When we're talking about Texas, it is so gutted reproductive health rights and justice that even if the Texas law is struck down, Texas is still considered the most deadly place in the developed world for a person to be pregnant. And that's not just Michele Goodwin saying this. When you look at the data from the CIA, as in Central Intelligence Agency, the United States ranks between 50th and 54th in the world in terms of maternal health and safety. It's actually safer to give birth in Saudi Arabia or Bosnia than in the United States. And when we look at this in terms of race, Black women are 3.5 times more likely than white women to die by carrying pregnancies to term. And those figures triple and quadruple depending upon what counties we're talking about in Mississippi, in Louisiana, and Texas. And so when we look at laws like SB 8, or we think about Dobbs, or when we think about voting rights, we're talking about fundamental issues that affect not only people's quality of life, but life or death itself. And let me just close with this. In Whole Women's Health v. Hellerstedt, a case from 2016 when the Supreme Court struck down 2 Texas anti-abortion laws, Justice Breyer quoted statistics from a study, a well-known study, that shows that a person is 14 times more likely to die by carrying a pregnancy to term than having an abortion. So you fit that in the conversation about Dobbs and also about SB 8. And what in the world could we possibly call that? Anything short of a death sentence that a state would impose, particularly on the most vulnerable and poor of people in its state. And that's a conversation that's really worth us not just having today, but continuing to have. And I thank you, Nan, for bringing this conversation to the fore, and also for being able to be in conversation with Chris and Elie, and also you, Emily.
Thank you, Michele. That is a lovely way to close out. Thank you to Alliance for Justice for putting this event together. It was smart and feisty, and in my view, that makes it a great tribute to Nan Aaron. Thank you all so much for joining us.